According to the rules of evidence in California, only relevant evidence is admissible. The key statutes here is Evidence Code Section 210, Section 350, and 351. Again, only relevant evidence is admissible, except as otherwise provided by statute. All relevant evidence is admissible. Relevant evidence means evidence, including evidence relevant to the credibility of a witness or hearsay declarant, having any tendency in reason to prove or disprove any disputed fact that is of consequence to the determination of the action. This is Evidence Code Section 210. Only relevant evidence is admissible except as provided by statute. Section 350 is the basis for excluding irrelevant evidence. Section 351 is the basis for admitting relevant evidence except as otherwise provided by statute. By statute, the rules of evidence are statute rules, not law. That's a big significance. That means the court still has common law in the sense that the court can interpret those statutes. Relevant evidence equals it has any tendency in reason to prove or disprove any disputed fact. It must be logically relevant, logical relevance. Evidence that is not logically relevant has no tendency in reason to prove anything. However, any tendency in reason means even the slightest. It may not prove it on its own. It may not make it even more likely than not, but it does provide a grain of truth to a fact. It is material. Materiality equals a fact that is in dispute, which means it is of consequence to the determination of the action. Again, Evidence Section 210 defines relevance. Even one grain of sand in that direction to prove X means that it is relevant and admissible because the courts want to come to the truth.